Thank you, Mark, for your generous introduction. Thank you to the MCC for bringing me to Hungary. Since I've been here, I've learned a lot about Hungary and a lot about international courts, so as far as I'm concerned, my visit has been a success. So as you heard, I'm not a lawyer. I'm an ethicist. And that means that there are things about the law I don't understand. Indeed, it means there are things about the law that I don't know I don't understand. But it also means that as an ethicist, I may observe things about the law and ask questions about it that a typical lawyer wouldn't ask. At the end of my lecture, I'm going to pose 4 questions, which, whether they reveal my ignorance or my insight, I would like your help in answering. The title of this conference concerns the purpose and limits of international courts. I'm going to express doubt about the wisdom of subscribing to them. I take it that the basic moral value of any social convention or norm is that it secures some valuable human liberty or benefit. What distinguishes a legal convention or norm, what distinguishes a law, is that it secures liberties or benefits more strongly through the social institutions of police, courts, and penalties. Quite apart from the specific liberties or benefits that it secures, law provides the general benefit of a reduction in conflict between members of society. What applies to national law applies also to international law. When states agree to the terms of a treaty, their future relations become more predictable and more cooperative, and the scope for conflict between them is reduced. Conflict is not eliminated, however, since the meaning of a legal text is invariably susceptible of different interpretations, especially in relation to different sets of circumstances. Yet the subscribing states are obliged by their subscription to conduct their disputes within the terms of the treaty they signed. International law, therefore, contains conflict in both senses, at once presiding over it and limiting it. In the absence of an authoritative international court to decide between vying national interpretations, the authority of international law is limited, but not entirely lacking. Sometimes, national leaders really do have more or less sensitive consciences whose commitment to moral integrity obliges them to take seriously the wording of the text they agreed to and to fit their interpretation of the law within it. And even statesmen with insensitive consciences will often be constrained by the need to maintain the trust of other co-signatory states, insofar as the breaking of that trust would entail the cost of diplomatic non-cooperation, perhaps even less than diplomatic retaliation in the future. The requirements of moral integrity and the prospect of the penalties of breaking trust themselves endow international law with a measure of authority quite apart from an international court. Without an international court, states do have reasons to limit and moderate their different interpretations of the law, and international diplomatic negotiation may resolve a legal conflict, but it may not. So the specific advantage of subscription to the jurisdiction of an international court with a decisive international court in agreement to abide by its decisions is that it endows the law with a decisive authority and thereby promises the great benefit of a standing means of resolving conflicts between nations peacefully. That is why some, not least I think in Germany, view the proliferation of international courts and the extension of their jurisdiction as the main way to rid the world of the scourge of war. So far, so good. However, When I was writing my book, What's Wrong with Rights, published in 2020, I believe I discovered two problems. One with international courts in general, and the other with the European Court of Human Rights in particular. Together, these problems imply, I think, that for a state to subscribe to the jurisdiction of such courts is to surrender national policy hostages to alien judicial fortune. The first problem comprises the political bias of the judges who sit on international courts, a bias shaped by the peculiar history and traditions of their own national states. This occurred to me when analysing the judgment of the European Court of Human Rights in one case arising from the United Kingdom's 2003 invasion and occupation of Iraq, and then considering it in the light of a judgment of the UK Supreme Court in another case. The Strasbourg case is that of Al-Skani, 2011, and let me warn you, much of the rest of what I say in this lecture will be an analysis and reflection on that particular case. This case concerned the deaths of 6 Iraqi civilians between May and November 2003. 5 were shot by British soldiers. The 6th, Baha Musa, died in their custody. In March 2004, the UK Secretary of State for Defence decided not to conduct independent inquiries into the deaths, nor to accept liability for them, nor to pay just satisfaction. As a consequence, the claimants appealed to the Divisional Court in London for judicial review of these decisions, arguing that their relatives fell within the jurisdiction of the UK and therefore under the European Convention, and that there had been no effective investigation into the deaths, breaching Articles 2 and 3. The European Court ruling began by reviewing the British jurisprudence, starting with the December 2004 judgment of the Divisional Court. The British Court, following Strasbourg's ruling in Benkovich 2001, accepted that jurisdiction under Article 1 of the Convention was limited to the territory of the contracting state, except where that state had effective control of an area outside its own territory. Yet even this exceptional basis of jurisdiction applied only within the European Convention's regional sphere, where the territory of one party was controlled by another party, and so it could not apply to Iraq. There was, however, a further exception, according to which jurisdiction could apply to a British military prison operating in Iraq with the consent of the Iraqi sovereign authorities and containing arrested suspects. So while deaths resulting from military operations in the field fell outside of the UK's jurisdiction under Article 1, the death of Baha Musa in a British military prison did not. The Divisional Court found, that there had been a breach of investigative duty under Articles 2 and 3 in respect of the 6th applicant's son. The first 4 applicants then proceeded to appeal against the Divisional Court's finding that their relatives did not fall within the UK's jurisdiction. The Court of Appeal of England and Wales dismissed their appeals in December 2005. Giving the leading judgment, Lord Justice Brooke argued that the British commander in Basra, and I quote, was not provided with nearly enough troops and other resources to enable his brigade to exercise effective control of Basra city. Therefore, it is quite impossible to hold that the UK, although an occupying power for the purposes of the Hague Regulations and Geneva IV, was in effective control of Basra city for the purposes of European Convention jurisprudence at the material time. On this point, Lord Justice Sedley concurred. On the one hand, he wrote, it sits ill in the mouth of a state which has helped to displace and dismantle by force another nation's civil authority to plead that, as an occupying power, it had so little control that it cannot be responsible for securing the population's basic rights. However, the fact is that it cannot. The invasion brought in its wake a vacuum of civil authority which British forces are still unable to fill. On the evidence before the court, they were, at least between mid-2003 and mid-2004, holding a fragile line against anarchy. The Court of Appeal unanimously concluded that the UK did not have jurisdiction under Article 1, except with regard to the sixth applicant's son, who, for the moment he was arrested by British troops, was subject to state agent authority. The first four applicants then appealed to the House of Lords. There, the majority found that the UK did not have jurisdiction over the deaths. They agreed with Lord Brown, who deemed Bankovich to be a watershed authority in establishing that the European Convention applies wherever a state party has effective control of an area. Given this, Lord Brown wrote, "Except where a state really does have effective control of territory, it cannot hope to secure convention rights within that territory. And unless it is within the area of the Council of Europe, it is unlikely in any event to find certain of the convention rights it is bound to secure reconcilable with the customs of the resident population. During the period in question, here, it is common ground that the UK was an occupying power in southern Iraq and bound as such by Geneva IV and by the Hague Regulations. Article 43 of the Hague Regulations provides that the occupant shall take all measures in his power to restore and ensure, as far as possible, public order and safety, while respecting, unless absolutely prevented, the laws in force in the country." End of quotation. The appellants argue that occupation within the meaning of the Hague Regulations necessarily involves the occupant having effective control of the area and so being responsible for securing there all convention rights and freedoms. So far as this being the case, however, the occupant's obligation is to respect the laws in force, not to introduce laws and the means to enforce them, for example, courts and a justice system, such as to satisfy the requirements of the Convention. Often, for example, where Sharia law is in force, convention rights would clearly be incompatible with the laws of the territory occupied. Now, the main point I wish to draw your attention to here is the sensitivity of the three British judges, Lords Brooke, Sedley and Brown, to political and cultural circumstances, the limited and inadequate resources of the military authorities in Basra in 2003-04, and the Islamic cultural context. In their reasoning, these circumstances are decisive in determining the inapplicability of European Convention rights. Such sensitivity was not consistently or decisively shared by their Strasbourg counterparts. So hitherto, I've simply reported to you what the European Court ruling reports about the British jurisprudence. At this point, I'm going to report to you what the European Court's own reasoning was. Regarding the issue of jurisdiction, the Court noted in Medvedev and Others versus France 2010 that the applicants fell within French jurisdiction by virtue of the exercise by French agents of full and exclusive control. On this, the Court commented, "What is decisive in such cases is the exercise of physical power and control over the person in question." The Court then concluded that it is clear that whenever the state through its agent exercises control and authority over an individual, and thus jurisdiction, it is under an obligation under Article 1 to secure to that individual the rights and freedoms under Section 1 of the Convention. Applied to the case before the Court, this principle produced the judgment that the United Kingdom, through its soldiers engaged in security operations in Basra during the period in question, exercised authority and control over individuals killed in the course of such security operations, so as to establish a jurisdictional link between the deceased and the UK for the purposes of Article 1 of the Convention. Thus, the Strasbourg Court tacitly took leave of its own ruling 10 years earlier in Bankovich, where it had declared boldly that the Convention was not designed to be applied throughout the world, even in respect of the conduct of contracting states. The Court did this by refusing to take into account the significance of circumstances. Observe how the criterion established in Al-Sadoun and Medvedev was control that is total or full and exclusive. But when applied in Al-Skani, it was relaxed without explanation to become merely formal control and authority. Observe, too, that this relaxation occurred in spite of the court's awareness that during the relevant period, the UK had been given responsibility for a territory with a population of 4,600,000 people, but had only 14,500 coalition troops to discharge it, and that the main theatre of operations within this area contained 2,750,000 people, but just over 8,000 troops. Indeed, the court itself quoted without demur the Aitken report of 22nd January 2008 on the post-conflict situation in Iraq, which reported of May 2003, the month of the first killing brought before the court, that, and I quote, law and order had completely collapsed. On the issue of the alleged breach of the investigative duty under Article 2, the court held that the article protecting the right to life and setting out the circumstances when deprivation may be justified ranks as one of the most fundamental provisions in the Convention, and that no derogation from it was permitted by Article 15, except in respect of death resulting from lawful acts of war. Since the general prohibition of arbitrary killing by agents of the state would be ineffective in practice without a procedure for reviewing the lawfulness of the use of lethal force by state authorities, and since in previous rulings the court had held that the procedural obligation under Article 2 continues to apply in difficult security conditions, including those of armed conflict. Quote, the obligation under Article 2 to safeguard life entails that even in difficult security conditions, all reasonable steps must be taken to ensure that an effective, independent investigation is conducted into alleged breaches of the right to life, end of quote. In order to be effective, the persons responsible for and carrying out the investigation must be independent from those implicated in the events. Therefore, the investigating authority should have been operationally independent of the military chain of command, whereas in fact it was not, and was therefore flawed. The delay in having a fully independent investigator interview military witnesses entailed a high risk that the evidence was contaminated and unreliable by the time that the Army Prosecuting Authority came to consider it. Therefore, the court found a violation of the procedural duty under Article 2 of the Convention. The court's reasoning here also bears critical reflection. Note, first of all, that Article 2 itself makes no mention of an obligation to hold an independent investigation, and its relationship to such a thing is not as strong as one of entailment. The prohibition of arbitrary killing does not draw all its authority from the threat of investigation, because it is also sustained by the consciences of soldiers and the moral training of their officers. So while the lack of an investigative procedure would certainly weaken the prohibition, it need not render it ineffective. Second, there was in fact an investigative procedure which was activated and presumably gave greater effect to the prohibition. But the court decided to raise the bar higher. For it to be effective, it asserted, the investigation had to be independent. This implies that the personal and professional independence of the investigator from those subject to investigation is necessary for impartiality. That is not true, however, because it is possible for investigators to possess such high moral integrity that they won't allow personal and other ties to sway their judgment. Independence merely makes impartiality more likely and more publicly demonstrable, but it is not strictly required for it. Besides, the investigative procedure that was implemented did involve a considerable degree of independence. It was not conducted by the troops immediately involved. From June 2003, all shooting incidents involving British Armed Forces were investigated by non-commissioned officers of the Royal Military Police, the RMP. and if thought to fall outside the rules of engagement, handed over to the RMP's Special Investigation Branch, the SIB. Then from April 2004, a new, more rigorous policy was adopted, whereby all shooting incidents that resulted in civilian injury or death were to be investigated directly by the SIB. For sure, the greater the procedural independence, the less likely that investigation will be corrupted by undue partiality. But the procedure merely reduces the risk of corruption. It isn't strictly necessary for integrity. This then raises the unanswered question: why did the Strasbourg court decide to make the perfectionist demand of minimal possible risk, even after it had admitted that in this case there was, and I quote, no evidence that the military chain of command attempted to intervene in the investigation, thus corrupting it? All the more so, why did it make this perfectionist demand in the wake of its admission that the obligation under Article 2 entails only that, in difficult security conditions, all reasonable steps be taken to ensure that an effective, independent investigation is conducted? Why did the court not allow the judgment of what is reasonable to be shaped by an appreciation of the circumstance of military exigency in a context of near anarchy? The text of the European Court's judgment in Arskeni, when I first read it, left me with the impression of a significant difference in reasoning between the British judges and their Strasbourg colleagues. The former were consistently sensitive to the way in which circumstances affect what the law can reasonably expect of human conduct in general and of occupying military authorities in particular, particularly when they're facing the collapse of law and order. In contrast to such empirical considerations, the latter were studiously impervious. The judgment of the British was prudent in this case, that of the Europeans imprudent. What the text of that judgment itself implied, two further pieces of evidence confirmed in my mind. One, a British dissenting opinion, the other, a Maltese concurring one. The former appears in the UK Supreme Court's 2013 ruling in Smith. This case concerned the deaths and serious injury of British soldiers in 3 separate incidents in Iraq. The first of these occurred on the night of the 25th of March 2005, when British Challenger tanks mistakenly fired at and hit another British tank, killing 2 members of the crew and seriously wounding 2 others. In Smith, it was alleged, under common law tort, a failure to ensure that the claimant's tank, which was hit, and the tanks that fired upon it, had been properly equipped with the technology and equipment that would have prevented the tragic mistake, and that the Ministry of Defence had been negligent in failing to provide the tank crews with adequate recognition training before deployment and in theatre. In an extensive dissenting opinion running to 50 paragraphs, Lord Mance identified the key question as that of whether the state can be held to have failed in its duty of care if a combat death can be attributed to its procurement and training decisions. In his view, and I quote, policy decisions concerning military procurement and training involve predictions as to uncertain future needs, the assessment and balancing of multiple risks, and the setting of difficult priorities for the often enormous expenditure required to be made out of limited resources. They are often highly controversial and not infrequently political in their nature. End of quote. Then Lord Mance pressed home his point by drawing upon his startlingly detailed knowledge of the Anglo-Zulu War of 1879 and the 2 world wars of the 20th century, commenting thus, "It will often not be difficult with hindsight to point to different decisions that might have been made or preparations made. Would the disaster of Isandlwana, let me explain, Isandlwana, 1879, the British invade Zululand, and a force of 1,300 British troops are overwhelmed by 20,000 Zulus and massacred, one of the worst military disasters of the 19th century for the British. Would the disaster of Isandlwana have been avoided had the army command equipped Lord Chelmsford's forces with a heliograph? Or was the cause the failure to form a laager, or the deployment of troops over too wide a perimeter, or the lack of screwdrivers to open the ammunition boxes quickly enough? And would many disastrous casualties of the First World War have been avoided if the War Office had recognised the significance of the proposal for a tank put to it in 1912, 1914 and 1916 by the Australian engineer Lancelot de Mol? Was the fall of Singapore in 1941 to numerically inferior forces with the ensuing slaughter and torture due to culpable failures to fortify the Malay Peninsula and landward side of Singapore, or to provide armoured vehicles or aircraft to protect both? Or was it inevitable in the context of what Churchill described as our bitter needs elsewhere? Again, observe the sensitivity to circumstances and appreciation of their constraints upon human conduct, informed here by a remarkably close familiarity with British military history. In stark contrast to this empirical disposition is the concurring opinion in Alskeni of Judge Giovanni Bonello of Malta. Here, the judge exhorted the court to, and I quote, "Stop fashioning doctrines which somehow seem to accommodate the facts, but rather to appraise the facts against the immutable principles which underlie the fundamental functions of the Convention." Appealing to the preamble of the European Convention with its agenda of the universal and effective recognition and observance of fundamental human rights, Bonello reminded his colleagues that the founding members of the Convention and the subsequently contracting parties, quote, "strove to achieve the supremacy of the rule of human rights law." On the issue of jurisdiction in Alskeni, Bonello commented with sarcastic gusto, "I resist any helpful schizophrenia by which a nervous sniper is within the jurisdiction, his act of shooting is within the jurisdiction, but then the victims of that nervous sniper happily choke in blood outside it. If two civilian Iraqis are together in a street in Basra and a United Kingdom soldier kills the first before arrest and the second after arrest, the first dies desolate, deprived of the comforts of UK jurisdiction, the second delighted that his life was evicted from his body within the jurisdiction of the UK. Same UK soldier, same gun, same ammunition, same patch of street, same inept distinctions. Did the contracting party ratify the Convention with the deliberate intent of discriminating between the sanctity of human rights within its own territory and their paltry insignificance elsewhere? I am unwilling to endorse a la carte respect for human rights. I think poorly of an esteem for human rights that turns casual and approximate, depending on geographical coordinates." So far, Judge Bonello appeared to think that the rights guaranteed by the Convention should apply everywhere, regardless of geographical coordinates. But then he admitted that the jurisdiction should be subject to a functional test, namely whether or not it was within the state's authority and control to see its positive obligations under the Convention respected. Applying this test to the cases before the court, he declared 4 times over that it was uncontested that the UK had authority and control, which is true, of course. No one contested it. However, what Judge Bonello went on to assert was contestable because it was entirely undemonstrated and unargued, namely that the United Kingdom had, quote, "full authority and control." My analysis of the unanimous ruling of the judges of the European Court in Alskeni appears to me to indicate an important difference between their legal reasoning and that of their British peers. The latter is sensitive to the way in which circumstances affect what's reasonable for the law to expect of human conduct, especially in a situation of near war. The former is not. In her review of my book, What's Wrong with Rights, Lady Hale, former President of the UK Supreme Court, described the ruling in Alskeni as a case merely of, quote, Strasbourg getting things wrong, since it subsequently changed its position in Hassan versus the UK 2014, conceding that convention rights should be modified to take account of the reality of armed conflict abroad, as Lord Sumption, she reports, explained in Al-Wahid versus Ministry of Defence 2017. To which my response is, well, that may be so, but it still doesn't give us a satisfactory explanation as to why Strasbourg got it wrong in Al-Skani. Was it because of a general difference between the English common law and European legal traditions, a difference in their way of reasoning, or between an English empirical inductive bent and a European theoretical deductive one, or between a way of reasoning informed by a persistent British national tradition of worldwide military operations on the one hand, and a way of reasoning informed by post-1945 European national traditions that tend toward practical pacifism on the other. Whatever the cause of the difference in legal reasoning, the result was a judgment that added unreasonable burdens to British troops in violent circumstances, likely to make them less willing to take the risks of aggression and so less likely to prevail over rioters or insurgents. Now, in case that should seem to you a thoroughly desirable outcome, consider this. In April 1919, General Dyer used disproportionate force in dispersing an unarmed crowd in Amritsar in British India, killing several hundred. In the wake of this massacre, the rules governing the use of lethal force by British troops in a civil disturbance were tightened. One unhappy consequence of this was that during the bloody intercommunal riots attending the partition of India in 1947, excessively cautious troops failed to use force to prevent widespread slaughter. Now, the cases of Amritsar in 1919 and those of troops in Iraq in 2006 were different, of course. But the relevant point is this, that making troops more cautious in using armed force can increase the risk of the collapse of civil order, rendering all rights ineffective and depriving the innocent of any protection. Now, from this very narrow jurisprudential base, my tentative thesis is that for a state to subscribe to the jurisdiction of international courts may be to surrender national policy hostages to international judicial fortune. The first reason for this, which I've just sought to explain, lies in the alien national traditions of legal reasoning of the judges who sit on international courts, as well as their alien political biases shaped by the peculiar history of their own national states. The second reason, which I'll explain much more briefly, and this has been raised several times already yesterday, pertains to the European Court of Human Rights in particular and concerns its doctrine of the European Convention as a living tree or living instrument. In the case of Catherine Smith, 2011, the UK Supreme Court held that the states subscribing to the Convention never intended it to apply to their armed forces in active service overseas. Insofar as the living instrument doctrine authorized the Strasbourg judges in Al-Skani to extend the authority of Convention rights to circumstances that contracting states, such as the UK, not only never intended, but would never have accepted. It undermines those states' confidence in the international treaty they signed. It gives them good reason to feel cheated, and so makes them more cautious in subscribing to anything similar in the future. In other words, it weakens international law and peace. What I'm not entirely sure about, however, is where exactly the fault lies in the doctrine of the living instrument. This is because, it seems to me, much interpretation of law involves creative reasoning, developing legal concepts and the meaning of laws in relation to sometimes novel sets of circumstances. Law is only applied to cases in the sense that the case also informs and develops the meaning of the law. That's to say, the traffic is two-way. It's a dialogue between legal principle and circumstances, not a monologue. So courts, it seems to me, are often bound to produce interpretations of law that the original legislators or national subscribers never quite envisaged. What exactly, then, is the problem with the European Court's doctrine of the Convention as a living tree? I see two possibilities. One is the Convention itself as a list of rights defined in very general terms, whose abstraction gives judges very wide, excessively wide room for intellectual maneuver. I'm assuming here a contrast with rights that come into being through legislation and which are more tightly defined because they are created in response to particular issues that have moved a government or a private member to propose legislation. The second possibility is that judges are motivated to exploit the room for maneuver given them by the Convention to develop and proliferate rights and to extend their jurisdiction by an ideology or philosophy that holds that the more rights there are and the wider the extent of their authority, the better. This, what I'll call rights progressivism, was well expressed by Jean-Paul Costa, the former president of the European Court, referred to yesterday, I think, who wrote in 2013, and I quote, "The preamble of the Convention shows that the aim of the Council of Europe, and therefore of the Court, is not only the protection of rights and freedoms, but also their development. This implies an evolutive and progressive conception of the rights that are recognized, and the Court would be failing in part of its duties if it attended only to the protection of the rights and ignored the imperative to develop them." Of this progressive rights gospel, Judge Bonella was evidently a zealous evangelist. Far from being embarrassed at the thought of, and I quote, "being branded in perpetuity a human rights imperialist," end of quote, he reminded his Strasbourg colleagues in Alskene of the European Convention's agenda of the universal and effective recognition and observance of fundamental human rights, and that all the states party to the Convention strove to achieve one aim, at once infinitesimal and infinite, the supremacy of human rights law. So in conclusion, let me pose 4 questions that my own reflections have left me with, and to which I have either no clear answer or no certain answer. First, what is the best explanation for the difference in sensitivity to circumstances between the British judges in Alskene and their Strasbourg counterparts? Was it simply an accident confined to a single case, as Lady Hale suggested? Or does it lie in a difference in the mode of legal reasoning between English common law and European legal traditions? Or does it lie in different political biases shaped by different national histories? Second, is there any reason to suppose that the problems I discovered in Alskene, if indeed they are problems, are typical of the rulings of the Strasbourg Court? In other words, is Alskene simply an accident or a symptom? Third, what exactly is the difference between the necessary intellectual creativity of any interpretation of law in the judgment of cases and the judicial activism or progressivism of the European Court? And what are its causes? Finally, if the confidence of national states in international treaties is at risk from the alien judgments and rights progressivism of the European Court of Human Rights, is it also at risk from every other kind of international court? And if not, why not? Or at least, is it at risk from some other courts? If not, why not? Thank you very much.